to do short sentences. Okay, welcome to our short workshop. There's so much press out there at the moment about the upcoming Employment Rights Bill. Some of it is scaremongering, some of it's false, some of it professes to know information that we can't possibly know at the moment. But we keep getting asked a lot of questions by our clients about what's changing, or we hear things like, I can't do that now because of the new rules, etc. So what we wanted to do is try to debunk some of the myths, let you know what you can expect to happen and when, and how you can potentially start preparing. It's really important to remember as we go through the things today, a lot of these measures still require consultation. So they have been presented in the House of Lords. House of Lords have remitted them back for some amends. That's likely to get ping-ponged back and forth a little bit. And they've also got to go through Royal Assent as well before they become law. So things could still shift in the grand scheme of things. But we do have a roadmap now for what's going to happen and the timelines. So what I'm going to do is work through the roadmap. We've got some very clear sort of dates for, certainly for the most pressing changes. We'll work through each section. I'll just run through quickly what the changes are, what sort of things you can look to do to prepare. And then I'll open it up to questions on those particular areas that we've just talked about. And then that way we can kind of keep it as contemporary as possible. I am recording the session today as well, just to let you know, just so that people who haven't been able to attend may potentially be able to get access to it. But let's have a look at the imminent changes first then. These changes are all subject to Royal Assent. Excuse me. Most of the imminent stuff really isn't going to affect most of you guys, I wouldn't have thought. Unless you recognise a trade union or you have lots of union members within your organisation, it's highly unlikely to affect you. But just to give you a bit of a brief summary as to what's going on, there's a lot of trade union stuff here. Repeal of the Strikes Act, so employers will no longer be able to rely on minimum service levels during strikes in certain sectors. Might have an impact on operational impact of industrial action for people. The repeal of most of the Trade Unions Act of 2016. So employers may face more streamlined strike processes. Thresholds and requirements for ballots are axed, removal of the 10-year ballot requirement for political funds, simplified industrial action notice and protection from dismissal for striking workers. So, as I say, most of the imminent stuff that's still awaiting Royal Assent isn't probably going to have that much of an impact on anybody on this call today, I wouldn't have thought. If it does impact you and you have got trade unions and you do want some advice on that, then please just give us a shout separately, because it's probably worth us just talking through that as a separate entity. So, excuse me. So let's take a look at what is going to impact you. April 2026 sees the first round of changes that will start to impact most of your businesses. Okay, and these changes really are as follows. These are the key ones. There are some other ones as well, which we'll talk about. These are the key ones. So day one, paternity leave. The UK at the moment has one of the most gender unequal statutory leave systems in the world. Shared parental leave was brought in about 10 years ago in an attempt to address this, but it got made so complicated, hardly anyone uses it. So in an attempt to address this, the government have conducted a full review of all statutory leaves. Paternity leave, the current status, if it's expected that you have responsibility for a child's upbringing, an expectant father or a partner of a pregnant person, they can currently take paternity leave provided they've got 26 weeks continuous service by the 15th week before the expected week of childbirth or notification of adoption. This is for 1 or 2 consecutive weeks. They may also be eligible for statutory paternity pay or company paternity pay if you offer that. The new proposal is making paternity leave a day one right, which means at least I won't have to keep repeating the 15th week before the expected week of childbirth, which is a bit of a mouthful, especially when I've got a really bad cough. It's important to note that this proposal is about the leave part of this only. It doesn't actually mention pay at this stage. It mentions leave, so they'll be eligible for leave from day one. Doesn't necessarily mean they'll be eligible for pay, although I suspect that probably will mirror. It also isn't increasing the amount of leave that can be taken, so it's likely to have a minimal impact really on businesses. In terms of preparation for that, it is just going to be a case of updating your policy, being aware of the changes, communicating them to any managers that may need to know. And obviously, if you are a Cube HR retained client, we will update your policies and things accordingly anyway, so you won't need to worry about that. For unpaid parental leave, they're also introducing day one rights. So at the moment, for unpaid parental leave, you currently have to have 1 year's service to be eligible. And you have to have parental responsibility for a child Parental leave, you can take up to 18 weeks overall until the child's 18th birthday, and that's a maximum of 4 weeks per year. The new proposal is again going to make this a day one right. So you will no longer have to have a year's service to be able to take parental leave. Again, that's really just a policy update and education. It'll have minimal impact. Most people don't use parental leave really, and it is an unpaid leave anyway. So from a business perspective, it will have very minimal impact in terms of the actual expenditure. Some changes coming to statutory sick pay that you will need to be aware of. So statutory sick, you currently have to meet a threshold for earnings before you're eligible for statutory sick. That threshold is going to be removed. So all employees, regardless of earnings, will qualify. However, they will be paid a lesser rate. So it will be 80% of their normal weekly earnings or the statutory amount, whichever is the lower of the two. Okay. There are also currently 3 waiting days, which are unpaid. When we look at statutory sick, they're also going to be removed. So statutory sick pay will start from day 1 of absence. Okay, so this is April 2026 when all of this will come into effect. These changes to SSP might impact you. It's likely you may see higher absence rates. Although the statutory amount of £118.75 per week is not a huge motivator for people to be absent. You can't reclaim the cost of SSP, so you may want to look to expect to budget a little bit more in your next financial year to cover the increased amount of statutory sick you may have to pay out. Other than that, again, it's just going to really be a policy update, educating managers, and if you work with an external payroll provider, just making sure they've got provision in place to make sure these changes kick in, which I'm sure they all will, to be fair. Other changes that you can expect in April 2026, again, really more around the trade union side of things, simplified trade union recognition. So current membership for statutory recognition is going to be reduced to between 2 and 10%, which at the moment is 10%, meaning that some unions might find it easier to gain recognition in workplaces where you've got a larger workforce. Changes to the balloting, so electronic and workplace balloting. There's also going to be some strengthening of protections and reporting channels for whistleblowers. So that might include a policy update for you. Again, we'll take care of that for you anyway. And possibly the need to include some training and some anti-retaliation measures. And sexual harassment will be added to the list of protected disclosures under whistleblowing as well. Some changes to the redundancy process, collective redundancy. So failing to consult properly before collective redundancies, that's where you're making more than 20 employees redundant at a time, could lead to double compensation awards. For those of you that have got businesses large enough that could impact, if you always follow our advice, you shouldn't fall foul of that anyway, so that shouldn't be an issue. And then the Fair Work Agency is going to be established. So Fair Work Agency is a new enforcement body that's set up to scrutinise employer compliance. It's going to combine the Employment Agency Standards Inspectorate, Gangmasters and Labour Abuse Authority and HMRC's National Living and Minimum Wage into one body. It means that you could be subject to audits, investigations or guidance offered from the agency. They are going to have the power to bring tribunal claims on behalf of employees where they themselves aren't going to bring a tribunal claim. And they will also be able to offer legal assistance to both employees and employers and pursue claims backdating up to 6 years of underpayments for things such as holiday and sick pay. We don't really know much more about that yet, other than the kind of the vague outline as to what that will look like. There really isn't an awful lot you can do to prepare yourself for the incoming Fair Work Agency. It will be what it will be, and we'll learn more about it at the time. Those are the key changes that are coming into effect in April 2026. Not huge amounts of things that are going to impact you. Does anyone have any questions on any of those changes before we move on? You can feel free to either unmute yourself or raise your hand or stick a question in the chat if you've got one, whatever makes it easier for you guys. But has anyone got any questions about that?
Two dogs break into their car last night and stole her designer sunglasses and all their wits out the car.
Leanne, do you have a question or do you need to mute yourself? Okay, cool. Okay, so I'm assuming there's no questions on that particular slide. Then we will have some time for questions at the end if needs be too. So the next set of changes is due in October 2026, which sounds a long way away, but it's really not when we think about the grand scheme of things. Some of the key changes that are coming into place. So the first one, a ban on fire and rehire. Currently, when you're making a key change to terms and conditions of employment, the way the process works is you consult with the employees, and then if you end up having to choose to impose those terms, you effectively dismiss and rehire employees on a new contract. Okay. Under the new law in October, that dismissal will be treated as automatically unfair unless you can show evidence of financial difficulties and demonstrate the need to make the change was unavoidable. So really, unless your business is in financial dire straits and you have to impose a contractual change to try to save your business, you're going to be looking at automatic unfair dismissal if you try to impose changes on somebody by dismissal and re-engagement. There is going to be a further consultation on that in autumn 2025, which I guess is going to be taking place soon. So that could be subject to a little bit of change. There isn't an awful lot you can do to prepare for this one, really. But if you are the kind of business where you do need to make contractual changes, maybe you want to think about doing that sooner rather than later before this kicks in. We do work with a client who tends to shift commission targets, for example. So we've written a policy for them to kind of say that the targets themselves are not contractual, and that the targets will differ depending on increases in certain rates, etc. It may or may not be enough to protect them to help them be able to make those contract changes, but it's worth having a think about. If you are looking at making any changes, maybe try and get them through this year or early next year. There's also some more reinforcement about sexual harassment. So the new law will strengthen the already changed laws on sexual harassment. So in October last year, the laws were tightened up to say that employers needed to take reasonable steps. The law will now actually say they have to take all reasonable steps. However, the clarification on what reasonable steps are isn't actually going to be set out until 2027. So not overly helpful, really, in that regard. With this, really, preparation is just reviewing of existing policies, carrying out a sexual harassment risk assessment to identify areas of risk where your employees might be at higher risk of sexual harassment, taking steps obviously to then mitigate those risks, reinforcing training to managers and staff to build awareness. It's not really any different to the changes that came out last year. Okay, it's just the wording of all reasonable steps rather than reasonable steps. So you will be expected just to make sure you are checking all those boxes. There's also going to be some introduction of third-party harassment liability. So employers will be required to ensure their team are not harassed by a third party, or such as a client or customer. Obviously, with sexual harassment, there is that duty on you already, but this is all types of harassment. So it covers all types of harassment and all protected characteristics that are set out in the Equality Act. Okay, so you may need to look at updating policies, and again, looking at, do you need to carry out a risk assessment to assess where your staff may be at risk of third-party harassment and how you mitigate those risks. I'd suggest, especially where you have employees who are in customer-facing roles like hospitality, delivery services, that kind of thing, where they are going out to visit customers, maybe where they're not going to be under your protection effectively, you probably are going to want to look at putting some risk assessment in place for that. An employment tribunal time limit changes. So currently people have 3 months less a day to bring a claim at an employment tribunal, okay, or at least to lodge their claim through ACAS. That's going to be increasing to 6 months. In all honesty, we're seeing that kind of delay anyway at the moment because the tribunals are so backdated. Even when somebody's lodging their claim at 3 months, we might not hear about it until month 5 or month 6. So all I would say with that in terms of preparation is just considering how you hold data, ensuring you keep it for a longer period. If you're dismissing somebody or you're dealing with a grievance or something that you think might be contentious and might go to tribunal, I'd suggest you make sure you keep any paperwork on that for at least 9 months. Okay, the backlog in tribunals means we're just not hearing about claims until 2 to 3 months after they've been submitted. So if somebody's got 6 months, it could take 9 months for you to even hear that a tribunal case is going through. It's just making sure that you are storing and saving any relevant evidence and materials for anything that might be contentious. Other changes that are probably not that significant for you, duty to inform workers of their right to join a trade union. That's really just going to be a simple change to your terms and conditions. We'll just be adding a sentence into your contract saying you have the right to join a union. That's it, really straightforward. Strengthen union access rights, so unions will have greater access to general workplaces. Rights for trade union reps, so employers need to support and not penalise recognised trade union reps. There's some extended protections from detriment to strikes, and then there's going to also be a fair pay agreement, but that's really going to just relate to adult social care sector. So this is where adult social care need to comply with sectoral pay standards and working condition agreements. And then there's some rules coming around procurement for public sector as well, which really aren't relevant to anybody as far as I'm aware on the call here today. That's October 2016. Anyone have any questions about any of those bits that are coming in October 2016 at all?
2016, Claire, we're going back 10 years.
That 2026, sorry. My brain is not working today. I do apologise. Yeah, 2026. Anyone have any questions about 2016 or 2026?
No, I don't think so.
No, bro. Okay. Let's get on to the meaty ones. Sometime in a galaxy far, far away in 2027. We don't know what month these are coming. It's just 2027 at the moment. Usually key employment law changes come into play in April and October. So I would expect these to either be April or October of 2027, but we don't have a specific timeline yet. These are where really some of the real key changes that are probably going to impact you are going to come into play. Okay. Firstly, gender pay gap and menopause action plans. This is only going to apply to employers with over 250 employees. But for those that have more than 250 employees, you will need to publish an overall gender pay gap report and have a menopause action plan to help address inequalities. Pay gap reporting is already in force, but this particular rule places a requirement for an action plan to be produced as well to try to reduce that gap. Okay, so if you already have 250 plus employees, you will probably already have to report on those gender pay gaps. But this is about putting an action plan in place to say, what are we going to do to address those pay gaps? Okay. Menopause action plans will include things like step taken to support and needs to be bespoke to each individual company. It might include things like education, awareness, support, well-being, adjustments, communication, culture, that kind of thing. We do have a menopause policy that we put into your handbook, which should be sufficient, to be fair. If you're smaller than 250 employees and you want that menopause policy, we can happily share that with you. That's not a problem. There's no reason why you wouldn't necessarily put a menopause action plan in place as a smaller business as well. It's a huge topical thing at the moment anyway. We are seeing claims coming to tribunal for discrimination on the grounds of disability, gender, age, when it comes to menopause, even though menopause itself is not classed as a disability. So yeah, it's worth having that action plan in place, even if you are a smaller business, really, to be fair. Strengthening of rights for pregnant workers. So from 2027, it will be unlawful to dismiss a pregnant person, someone who's on maternity leave, or someone who's returned within 6 months of that return. Okay, so at the moment, obviously, it's already unlawful to dismiss someone who's pregnant or who's on maternity leave. The protection will extend to people within 6 months. So when someone comes back from maternity leave, they will still have those protections for 6 months from their return date. There will be exceptions to that rule in situations of redundancy where you are essentially closing the business or closing the whole department, for example. So there will be exceptions to that rule for those specific circumstances. Flexible working reform. So flexible working, strengthening of the existing reforms. Flexible working will be the default from day one, apart from where that is unfeasible. Okay. You will still be able to refuse flexible working requests on the 8 business reasons that you already have available to you. But the general kind of gist of this law is your answer will be yes, unless you can prove it's a no. Rather than at the moment, it tends to be the answer is no, unless the employee can prove it's a yes. Okay. Realistically, it's not going to amount to much in the way of change for you, as long as you've always got an open mind to flexible working requests anyway. It may mean that you just want to strengthen your recruitment processes by discussing flexible working options at recruitment stage with people, just to make them aware of which jobs can and can't have flexibility, rather than taking someone on and then getting blindsided 2 days later with a flexible working request that you've then got to process. Probably good practice to start doing that now, to be fair. Bereavement leave. So there will be an introduction of a day one right to at least 1 week of bereavement leave. Okay, so at the moment, your compassionate leave policies are purely discretional for you. There is no law that requires you to allow people to take bereavement leave, save for shared parental bereavement leave. There will be a statutory policy on bereavement leave. We don't know yet what level of relationship that will go to, whether it will be immediate family, whether there'll be some definition of what relationship the bereavement leave will be eligible for. There will also be 2 weeks of statutory leave for anyone who experiences pregnancy loss before 24 weeks. Okay, so parental bereavement leave and maternity leave and those kind of policies at the moment only cover from 24 weeks plus. This will be a pregnancy loss policy prior to the 24 weeks. So it'll include people that miscarry early, that are going through IVF, that have ectopic pregnancies, that kind of thing. But again, that is going to be consulted on in autumn 2025. Okay, might be worth having a look at your existing bereavement leave policies and just thinking, is it fair and reasonable? Do we need to set this out? Where you have bereavement policies that sort of make bereavement leave discretional, maybe you want to have a think now about putting some rules in place about how much time people are allowed to take, and then hopefully that will tend to mirror the policy that's coming into place. We also do have a pregnancy loss before 24 weeks policy already in place for anyone who does want that in the handbook as well. It's something we wrote with somebody who was actually campaigning for this law to be brought in. We don't put it in as standard because not everybody wants to have it in, but if you do want access to that, please just let me know at the end and I'll be able to provide that for you. A ban on 0 hours contracts. So 0 hours or low hours workers will have the right to request a guaranteed hours contract that reflects the hours they actually regularly work. And that's likely to be across a 12-week referencing period. Okay. The House of Lords have suggested that they tweak this slightly. So the House of Lords have suggested this policy gets tweaked so that it's a voluntary thing, so that they have the right to request, but they don't have the right to demand effectively. Initially, the bill was written as if everybody who was on 0 hours or low hours would have to have this review done on that basis. So it is going to be more of a voluntary thing. There are plenty of people who are quite happy being on 0 hours contracts or low hours contracts. It suits their lifestyle. So hopefully with the amends that will come into play, it will be a request thing. So they will have to request that. Worth having a think about how many people you've got in your organisation that might impact. Planning for any changes that might come in, how might that impact your budgets, your staffing levels? And actually, if you are already operating on 0 hours or low hours contracts, are they necessary and fit for purpose? Okay. Do they still suit your operational needs, or do we need to have a review of those and actually get people onto some regular hours anyway? Okay. And then the biggie, the one that everybody is quite fearful of, is the day one right to protection for unfair dismissal. Okay, so at the moment, you have to have 2 years service. This is purely related to unfair dismissal claims, guys. Unfair and constructive unfair dismissal claims. We already have automatic dismissal claims from day one, which is around discrimination stuff. People can already claim tribunal claims from day one for discrimination. This is purely around unfair dismissal and constructive unfair dismissal. So that 2-year qualifying period will be removed and it will be replaced with what they're proposing will be a statutory probation period. So that's likely to be up to 9 months. Okay, it's been suggested by the House of Lords that this bill isn't fit for purpose. It should be changed. They are suggesting that we should lower the qualifying period to 6 months. The stance seems to be at the moment from Parliament that they're going to be pressing on with it anyway, that they're not going to listen to those recommendations, because this day one right was something that was huge in their campaign when they came into power. So how do we prepare for that? I mean, in reality, obviously, it's not going to change till 2027, but preparation needs to include robust recruitment processes, robust induction processes, and making sure you've got a good probation process in place. Okay. Any updating of policies to remove short service limitations will sort for you. That's fine. In reality, we are seeing so many claims being turned into discrimination claims anyway, when people don't have the length of service. It might not feel as impactful as it seems. Okay. The statutory probation period will still require a process from you, but it will be a lighter touch process than the full-on disciplinary process that you currently have to follow with people who are over 2 years service. Okay, but you will need to clearly demonstrate that someone isn't right for the job. What that means is you are going to have to make sure you effectively communicate and document conversations. This is the area that I can't stress highly enough, and we stress this a lot in all of our training, is you've got to document conversations you have with people. This is a lot of time where people fall foul. They'll have conversations about performance, they have conversations about conduct or about attendance, but they never actually document it. Documenting it is going to be crucial. You are going to need to use your probation period to document the fact that you've communicated concerns, you've given them a chance to improve on those concerns, their understanding of what the consequences are if they don't improve on those concerns, and then there will be a process to follow to be able to safely dismiss somebody. Okay, You will also have to provide written reasons for dismissal as well after the statutory probation period. So at the moment, if we dismiss someone under 2 years service, technically speaking, we don't have to provide them with written reasons for that dismissal, although it is good practice to do so in all fairness. But you will have to provide written reasons for dismissal after that statutory probation period has expired. There is one sort of small bright light, I guess, in all of this. Anyone who's dismissed during that statutory probation period and effectively brings a claim in a tribunal will likely have a much lower compensation cap for that tribunal. Okay, so unfair dismissal claims have a cap. I think it's about £93,000 at the moment. There will be a lot lower cap on compensation that people can claim within that statutory probation period. So at least if you, worst case scenario, do find yourself in a tribunal and you do get awarded against, hopefully it won't be astronomically expensive for you. A few other changes that are still on the horizon for 2027. Regulation of umbrella companies. So where employers use umbrella companies for people who are self-employed to get around the IR35 rules, you have to make sure that those umbrella companies are following employment law. So you will have to make sure you do due diligence and compliance checks. A blacklisting ban, so stronger measures against informal blacklists. Again, this goes back to really trade unions, ensuring there's no recruitment bias or informal exclusions taking place. There'll be a framework for industrial relations, so broader reforms for things like disputes, negotiations, union engagements, etc. Agency worker and 0 hours contract protection. So the stuff we talked about with the 0 hours workers and with the low hours workers, those protections will also extend to agency staff as well. So agency staff have the right to also request guaranteed hours. Okay, so if you do use agency workers, coordinate with that agency to ensure you're dealing with that on fair terms. And the collective redundancy consultation threshold. So this is going to lower the threshold for consultation. So at the moment, if you're making 20 or more redundancies at one establishment, that would count as a threshold. Whereas if you're doing it across multiple establishments, normally you can treat each establishment as a single entity. This will bring together any establishment. So the ruling will be 20 or more redundancies at one establishment or a certain number or percentage across the whole of the business. So only really applicable for you if you've got multiple sites where that might potentially become an issue. A couple of other things that are on the horizon without a timeline before I open it up to any further questions. Equal pay rights. So they're looking to introduce the right to make equal pay claims for Black, Asian, minority ethnicity people and disabled employees. So it'll become a racial and a disability equal pay as well as the gender equal pay that we've already got. Establish an equal pay regulation and enforcement unit that ensures outsourcing of services can't be used by employers to avoid paying equal pay. Okay, so it'll just be around making sure that you've got those structures in place. If you are going to be in that larger employer bracket, so if you have got 25 plus 250 plus employees, they're also going to look to introduce ethnicity pay gap reporting as well, and disability pay gap reporting, as well as the gender pay gap reporting. Okay, so if you are in that category, you need to start having to think about how you can do that. Have you got the data available to collate that? Do you gather that data already? Okay, and then building on the carers leave that was introduced recently. At the moment, people are entitled to take carers leave. It's unpaid leave, and they are looking to introduce paid carers leave. I guess it will likely be in line with other statutory payments, such as statutory maternity, paternity, etc. These are changes that we don't have a timeline for at the moment that are still hugely in consultation. So not really anything you need to worry too much about at this stage. That kind of brings us to the end of the roadmap and the session. Before I do open up to any other questions, I have got a free resource that I'm going to share with you all. Our lovely Laura, our new HR consultant, put together a cracking spreadsheet that allows you to quickly identify which of the issues might have an impact on your business. So which ones are high impact, which ones are low impact, and just give you a bit of a timeline then for starting to plan for those changes and prepare. So I will share that spreadsheet with all of you after the session. And hopefully you'll find it useful to set yourself out your own little preparation roadmap for the changes. But does anyone have any questions on the back of any of those things? Feel free to unmute or type on the chat if there are any. If you've not got questions and you're happy to leave it there, you're welcome to pop off. I know I diarised an hour. I didn't think it'd take an hour, but I diarised an hour just in case because I didn't know how many questions there would be. So, Suzanne, read the 1 week bereavement leave, whether paid or unpaid. It's a bit of a tricky one to answer. At the moment, there's no reference to pay, Suzanne. It's just about the leave. There's no actual reference to whether that'll be paid bereavement leave or not. So that would probably still at this stage be discretionary on the employer. They may introduce a statutory payment, but again, it would be a statutory in line with the other statutory payments. And it would be your discretion as employer whether you wanted to give more than the statutory payments. Lots of companies do already pay for say a week's bereavement leave for immediate family anyway, so that may be open to discretion, but yeah, there's no mention of a statutory payment at this stage.
No question, Claire. Just wanted to say thank you. I'm going to drop off. Thank you so much.
Yeah, no worries, Nicole. See you later.
Bye.
Do apologise for the massive coughing fits as well that I had at the beginning. Everyone's typing a question, so I will wait to see what comes on that one. Unfair dismissal rights, is the notice period up to 9 months, or is this? So it's not the notice period, it's the probation period, Yvonne. So at the moment you have a probation period in your contract. It might be 3 months, 6 months, but it's a company choice of probation period. So it'll be a statutory probation period for 9 months. What that'll mean is you can still have your own contractual probation period that you work towards. So you might still have your own probation duration. That 9-month probation period will really be, I suppose it's a little bit like your short service at the moment. So if an employer's under 2 years, there are shortened processes to get to dismissal. Really, that 9-month probation period will be that shortened process. So you will be able to dismiss them on the grounds of unsatisfactory performance during that probation, but there'll be a process that you'll have to follow, but it won't be a full-on disciplinary process. But you can still have your own contractual probation periods, but it just won't cover the protection. So you might have a probation period of 12 months, for example, if you've got people in particularly senior roles. You can still have that probation period, but between that 9-month and 12 months, you won't be covered under that shorter process. You'd still have to do a full formal disciplinary process with somebody, written warning, final warning, escalation. You wouldn't just be able to move straight to, you're not suitable for the role, we're dismissing you. That makes sense. Any other questions, guys? Feel free to unmute yourselves if you want to ask. I don't mind if people want to talk to me.
So could I just ask, please, Claire?
Yeah, of course.
So what I meant was, with the probationary period, can you do a shorter probationary period?
Yeah,
Or is
you
the
can do a
one you can
shorter.
do?
Yeah, you
Yeah.
can do a shorter one. I think the thing to probably be mindful of there is, if you've got those protections for 9 months, it might be worth just having that 9-month period, because it just keeps you protected then from being able to dismiss somebody a little bit more safely if they're not suitable. But you can still have a 3-month probation period in your contract if you want to. It's still a little bit of a grey area, because until we get the full policy from ACAS on what that looks like, because this will form a change to the ACAS Code of Conduct on Disciplinary and Grievance. Until we get that full change, we don't still really know exactly what the rules will be. So we're having to interpret a little bit what is coming out. But the ruling says you can have your own probation period, but the statutory 9-month will be that protection period for you as a business to be able to say, this person's not working out. We've got a slightly shorter disciplinary process through that period. So I really do see it as a little bit more like, at the moment we have those 2 years, we're going to have 9 months. It's almost like saying it's a 9-month period, really. They're just using the term probation period, I think, just to make it sound a bit more fancy than what it is. Any other questions?
Thanks, Claire. Just one more from me.
Yes,
regarding the union, is it like you say, just a simple line in the contract, you have the right to a union?
Yeah, I think so, pretty much. We already have in the contract of employment, you'll already reference whether there are any collective agreements in place for your particular organisation. Most of you don't have union recognition, so most of them will say there are no collective agreements in place. I would suggest we just add a sentence at the end of that that says, we are informing you that you have the right to join a trade union of your choice, but we as a business don't recognise an official trade union. It'll be something like that. It'll just be a one-liner in the contract just to make them aware. I doubt we'll have to have a full-on policy about unions, because at the end of the day, once you've told somebody they've got the right to join a union, what more can you tell them? You know, it's their choice which union they then choose to go to. If you're not a unionised business, it's their choice which union they then go to.
Yeah.
So you wouldn't really be able to give them a lot more detail. So yeah, I think it'll just be a sentence.
Okay, thank you.
Hi Claire, it's Jo. I don't know
Hi,
what's going
Jo.
on with my hello. I don't know what's going on with my camera, and I'm still recovering at home. So do apologise everyone for the cockatoo
right.
and the dogs that you will probably hear because they're so noisy. With regards to the Fair Worker Agency, some of the things that it sounds like they do is very much what I'm now on hold. Oh,
You mentioned my dog goes boo. Sorry.
oh, what's going on?
Right, sorry about that. My dog decided to go boo at the postman. Sorry, Jo, just repeat that for me.
Sorry, I went on hold then.
That's
Sorry
it.
about that.
That's
What's
okay.
going on?
Just repeat your question for me. Sorry, because the dog
So,
was going
yeah.
mental in the background.
Oh, sorry. So with regards to the Fair Work Agency,
Yeah.
some of the things that you were saying that they're looking at doing sounds very much what ACAS already does. Who
Mm.
trumps who? So if you've got a worker that doesn't get an answer from one and then goes to the other, I mean, like what this sounds like it's going to be very conflicting on what happens.
Yeah, it's really tricky. I don't know is the answer to that question at the moment. I've given you all the information that I actually have on the Fair Worker Agency. I suspect because they're going to be a government body that will have permission to go to tribunal on behalf of employees if employees don't take it. It will be more around pay and that kind of thing, not necessarily around kind of unfair dismissal disputes and that kind of thing. It'll be more around, I've not been paid holiday pay, I've not been paid sick pay, I've not been paid national minimum wage, those kinds of claims. I suspect they will probably take authority on those kind of claims. And I suspect ACAS will probably divert people to them for those kind of claims, because ACAS are massively overwhelmed as well at the moment. ACAS are talking about bringing in AI to mediate between employer and employees, because they are so overwhelmed with cases. So I suspect it'll be, if it's a case around holiday pay, sick pay, that will happen. So gone offline again, Jo. She's gone offline again. Any other questions, guys? No? Okay. I mean, I will share the recording out with everybody, and I'll get the spreadsheet shared out as well for anyone who wants to have access to that to take a look and to utilise that. If anyone's got any questions or anything following on the back of it, just you know where we are. Just drop us a call or an email, and let us know. If you want to discuss any of the union stuff, obviously we'll go through that. But yeah, we will keep you updated as soon as we get updated policies. So what you'll probably find is, for those of you that are retained clients, when we get to March and we've got the first round of policies coming in, we'll start sending out updated things for you. We'll do another round of that, obviously September, pre to October and so on and so forth. And we'll just keep communicating with you and keep you as updated as we possibly can. Just like back in. You back, Jo?
I'm back. I don't know what the hell is going on. I've got superb internet connection, so I don't know why it just keeps kicking me out. I do.
That's all right.
Well,
I'll call you later. I'll give you a call and we'll have a chat through it.
it might be
because I've already
easier.
answered your
It might
question.
be easier. Thank you very much for that.
Okay, thanks very much, guys. Unless anyone's got any other questions, you're free to go, or please stay on if you want to have a chat about anything.
Thank you. Bye.
Bye.
Thanks, Claire. Bye.
Cheers.